Hello and welcome. This is Grant Hughes of Grant Hughes Investigates on YouTube. This channel evaluates all aspects of true crime. As you are aware, videos and live streams in this genre often discuss elements of crime that may be disturbing to some viewers. If necessary, take the precautions needed to avoid these feelings. Factual information related to cases is the key to fostering rational true crime discussions. Fortunately, you will find that here. Please hit the like button only once, share the video, and subscribe if you like my content. Thank you very much for watching.
Huh?
Well, looks like the, oh, they're actually cleaning out that thing. Oh, well. Hello, freaks. I don't know, getting kind of bored of the protest thing. It's just the same thing over and over. You know, if it gets really crazy or something, yeah, maybe take a look at it. How's everybody doing? I'm gonna try to go fishing in the morning. Haven't been fishing in a long time, like a month or so. Gonna give it a shot. I don't know, Nikki's is. Maybe go out and try to find it and go watch it somewhere. I got some other stuff I gotta cover. See. Yeah, so maybe the first thing we'll do is the Thomas Crooks. Remember the guy, the person who tried to take out Trump in Pennsylvania? Let's see. There's like this video of him, but you can't really see it. I mean, it's on. Obviously you can see more of it, but.
Thomas Crooks. It has always been my passion to create and build things of my own. Today, I want to tell you a little bit about myself and my academic goals, my passion.
See what it looks like. It looked more like this though when he's standing up, but then there's a paywall here.
It's been my passion.
I'm not sure if there's more to it.
Create and build things of my own. Today, I want to tell you a little bit about myself and my academic goals, my passion for building things, my love of cooking with my family, and lastly, what I hope to achieve in this course. Hello, my name is Thomas Crooks.
So it just kind of starts over. I don't know if that's what it does, right? Or like if you get the paywall, then it's a longer thing. I don't know. And then just today, Fox News put out a report gives new details on Trump assassination attempt. Suspects descent into madness. What's this one?
I had zero relationship to the family. I've just encountered the gentleman. Wouldn't call him a gentleman, but walking up and down the road as he would go to work, I believe.
And how far do you live from the house?
About 4 doors down, normal size Bethel Park yard, so I'd say 400 or 500 yards.
And so what would you witness with the family? Any interactions that you had?
No interactions with the family, just what neighbors had told me about them since this incident happened at the present.
Yeah. Anyways, right here it says the 20-year-old gunman who tried to assassinate President Trump at a rally in Butler, Pennsylvania last summer experienced a descent into madness leading up to the incident, during which he was having conversations with someone that wasn't there, a new report says. The New York Times, citing thousands of pages of school assignments, internet activity logs, and interviews with dozens of people who knew Thomas Crooks and the investigations surrounding him, among other documents, reported this week that he went through a gradual and largely hidden transformation from a meek engineering student critical of political polarization to a focused killer who tried to build bombs. There was a mysteriousness to Thomas Crooks' descent into madness. Representative Clay Higgins of Louisiana, who served on a congressional task force that investigated the July 13th, 2024 shooting, told the newspaper. So I guess this is, man, I wish I could just see this one article, but, you know, I guess that's why it's behind a paywall. He was having I used to have a New York Times subscription. Let me see, maybe I do. Hold on. Let me just try to... Okay, yeah, it has me in there, but I think I let it lapse or something. I wasn't using it too much. There was a mysteriousness of Thomas Crooks' descent into madness. And then he was having conversations with someone that wasn't there, Higgins added, after learning information about Crooks' mental health during a trip to Pennsylvania to investigate the assassination attempt. Prior to the shooting targeting Trump, the only time Crooks got into trouble was receiving lunch detention in middle school for chewing gum, according to the New York Times. The newspaper reported that Crooks scored 1530 out of, that's a really amazingly good SAT score. 1530 is like you can go to any college you want with that one. Out of a possible 1600 on the SAT, and graduated from the Community College of Allegheny County, where he spent several semesters on the dean's list while earning an engineering degree. He was preparing to transfer to Robert Morris University, located outside of Pittsburgh, telling classmates he wanted to have a career in aerospace or robotics. Thank you, Allie K. The newspaper added. However, Crooks' father...
Ocean wave emoji. Ocean wave emoji.
Notice his son's and thanks again, Allie Cake. She has a wave up there. Especially after the May 2024 graduation, telling investigators he had seen Thomas Crooks talking to himself and dancing around in the bedroom late at night. But I'm not sure how you believe, in this case, what the parents are saying. The newspaper said the alleged behavior coincided with a history of mental health and addiction struggles in Crooks' family. So maybe, might be something to it. The New York Times reported, citing portions of a report from the Pennsylvania State Police. What's that? Oh, it's showing up on my other computer. That's so weird. A classmate said to the newspaper that during high school, Crooks enjoyed talking about the economy and cryptocurrencies. At community college, he reportedly designed a chessboard for the visually impaired, such as his mother, the New York Times added. He seemed like a really intelligent kid. I thought he would be able to do whatever he wanted, Trish Thompson, who taught Crooks engineering at the Community College of Allegheny County, told the newspaper. About a year before graduation in April of 2023, Crooks reportedly wrote an essay in favor of ranked choice voting in American politics, arguing against divisive and incendiary campaigns which are pulling the country apart. As we move closer to the 2024 election, we should consider carefully the means by which we elect our officials. Crooks was quoted by the New York Times as saying, "We need an election system that promotes kindness and cooperation instead of division and anger." Yeah, so you remedy that with zero kindness in killing people? What a loser. Around that time, the FBI said Crooks made more than 25 different firearm purchases from online vendors using an alias. One purchase that Crooks made with an encrypted email account was gallons of nitromethane, a fuel additive that can be used to build explosives, according to the New York Times. He reportedly listed his home address for the delivery. Sounds a little bit like Kohberger ordering the K-bar knife. In the summer of 2023, Crooks joined a local gun club, the New York Times reported. The newspaper added that Crooks visited news and gun websites as well as the Trump administration's archives before narrowing his online searches in the days leading up to the attack to queries such as how far was Oswald from Kennedy. Searches also included major depressive disorder and depression crisis, the Times said. He also reportedly continued to show up for his job as a dietary aide at the Bethel Park Skilled Nursing Rehabilitation Center in the weeks leading up to the Trump assassination attempt. On the night of the shooting, ATF agents visited Crooks' home in Bethel Park but had to evacuate after one spotted an ammunition can with a white wire coming out and a gallon jug labeled nitromethane in his closet, according to the New York Times. It's weird. Thomas Crooks doesn't have the physical structure of his parents. I mean, it looks like it probably is their kid, but outside, the property agents then interviewed Crooks' parents with them, saying he liked building things and visiting the gun range, and his father also reportedly claiming that he did not know anything about his son. Yeah, I don't know. It's hard to say that what the dad says is going to be accurate. You know, the what's like Dan Bongino, you know, like he's working in the, what is it? I can't remember which department he's under. But, you know, he was always into the conspiracy angle of this, and he said they can't find anything. There's no outside connection. And then that's the problem for people who believe in conspiracies all the time. So now Dan Bongino will be called out by those same people, even though he was one of them. And obviously he is going to tell everybody whatever the hell he finds. But they didn't find any other connections. They don't know why he acted the way he did. And so now all the people out there, they were like, yeah, get in Dan Bongino. And then they're going to go, oh, see, he's a sellout. Instead of just going, geez, maybe they really couldn't find something. No, he wasn't. Black Owl Company. Let's see. That's just such a crazy, that's just absolutely bull crap. He wasn't a Trump supporter. He hated him. He might have been a Republican registered at some point, but that doesn't mean anything. All right, well, that's basically the update there. On that. And while we're doing this show, you guys, if you want to help support the channel, that'd be great. You know, if you can't afford it, then hit the like button. But if you can support the channel, I would appreciate it. Oh, there goes my stomach. Yeah, there was a bunch of articles, like the same ones that we read yesterday that came out, documents. I'm just trying to find the ones that were, okay, there's one that's, I want to look at that one. The ones that are 3 pages or more. You know, let's see, what's this one says? Supplemental Notice of Compliance. Regarding the state's log spreadsheet identifying objections, forget that one. Let's do this one right here. Is 22 pages long. This is like an importance, the argument against allowing for a delay in the case. Thank you, Forgetful Mandy. All right, here we go. I'm just going to read the whole thing. I've already done the what we can do. How about we do the Chat GPT sort of breakdown of it first, then we'll just go over the whole thing. All right. So right here we go.
The document titled, State's Opposition to Defendant's Motion to Continue is a highly detailed 17-page legal response filed by the state of Idaho on June 5, 2025, opposing Brian Kohberger's request to delay his trial. It is structured to demonstrate that a trial delay is unjustified, unwarranted, and detrimental to victims' rights. Below is a comprehensive high-detail summary by section. 1. Introduction. The state argues it's time to try the case, highlighting that Kohberger was arrested in December 2022, was indicted in May 2023, had his request for venue transfer to Ada County granted, complied with court-set deadlines and submitted extensive disclosures for both guilt and penalty phases, e.g. 6 penalty phase expert reports, 2,100-plus pages of mitigation material, 55 witnesses, 132 exhibits. The defense now seeks an unspecified length continuance, citing incomplete mitigation investigation. The state claims the defense has not identified any specific missing evidence and argues additional investigation is speculative. The motion is labeled a last-minute tactic lacking good cause or proof of prejudice, emphasizes victims' rights under Idaho law to a timely disposition. 2. Procedural and factual background. Defense team composition, 3 attorneys, appointed December 2022, March 2023, February 2025, 2 investigators and a mitigation specialist. Change of venue, granted January 2024. Scheduling order, issued October 9, 2024, setting deadlines. Court guidance. April 2025, directed defense to seek
really
more resources if
document.
needed, unclear if they did. Defense submissions. January 2025, disclosed 16 guilt phase expert reports. March 2025, supplemented with 2 more experts. March 31, 2025, submitted amended penalty phase reports plus 4 new expert reports. June 2025, disclosed 2,100-plus pages of mitigation material, 55 witnesses, 132 exhibits. 3. Legal framework. Courts have broad discretion to grant, deny continuances citing Idaho and U.S. precedent. Denial must be so arbitrary it violates due process. This is a high bar. Appellate courts require a showing of prejudice to reverse a denial. The bare claim that more investigation could help is not sufficient. Courts must also consider Idaho's Victims' Rights Amendment Art, ISS 22, and Idaho Code SS 19 to 5306. 4. Argument. Reasons to deny continuance. I. No good cause or prejudice shown. A. Motion is untimely. All discovery and expert deadlines have passed. Pretrial conference occurred. No new specifics on what evidence is lacking or how delay would help. Defendant previously objected to the state's request for more time. State argues same standard should apply to him. B. Claim of incomplete mitigation investigation is unsupported. Legal team resources are robust. 3 attorneys, 2 investigators, 1 mitigation specialist. Court offered more help if requested. Defense didn't ask. Expert resources are ample. 6 penalty phase experts, 5 mental health, diagnoses autism, OCD, ADHD. Extensive life history already compiled. No requests to extend disclosure deadlines for experts. Life history investigated extensively. Defense's use of ABA guidelines deemed overblown. Idaho courts and U.S. Supreme Court have held these are non-binding. Table 1 and Table 2 appended to show that all areas the ABA identifies have already been investigated. Defense's reliance on cases where courts failed to consider existing mitigation is irrelevant to this issue of delay. Ex parte filing irrelevant.
We could try to do the, I don't know if anybody's even paying attention to that. I could tell by the comments. Let's see if we do the break it down in bro mode. Let's see what happens. Thank you, Simply Suspicious Shauna. Simply Suspicious. You are simply suspicious.
The user requested a bro mode breakdown, and they probably don't need citations, just a fun, informal summary. However, the file search output came with some reference markers, like 8 for the document. May 2023, grand jury says, "Yup, charge him." January 2024, venue moved from tiny town Latah to big boy Ada County. October 9th, 2024, judge drops a scheduling order with every deadline imaginable. BK's team hits every date. Then, after the finish line, yells, "Wait, time out," asking for an unlimited delay. 2 states opening punch. It is time to try this case. Translation, bro. You've had 21 halves years. Stop the excuses.
2.5.
3 receipts the state slaps on the table. Category what? BK already has state's Mike Droployer's 3 death-qualified attorneys plus staff.
How many chefs do you need, Gordon Ramsay? Investigators 2.
Full-timers hire a 3rd if
That's weird that they have that other voice.
you're lonely. Mitigation. Expert-owned specialist digging through BK's life already on payroll, dude. Expert 16. Guilt phase. 6 penalty phase. 5 mental health pros, whole psych department on speed dial. Paper. Pile 2,500 plus photos, videos.
I'm just going to go right there.
30,500 plus pages discovery, 2,100 pages mitigation. If you printed...
I don't know, it doesn't break it down the right way. There's all these charts and then it doesn't read it right. So forget it. Let's just go over this thing. All right. It doesn't break it. Doesn't... whenever it does the little charts like that, it doesn't read it right and then it sounds weird. Comes now the state of Idaho by and through Latah County prosecuting attorney and submits the following opposition to the defendant's motion to delay the trial, is basically what it's saying. It's time, and then the introduction, the first sentence is this: it is time to try this case. Defendant was arrested in late December of 2022 and was indicted in May of 2023. He successfully moved to transfer venue to Ada County. In October of 2024, this court entered its scheduling order, setting deadlines for potential motions and expert disclosures. Defendant complied with those deadlines without moving for a continuance, including by disclosing 6 expert reports for the penalty phase, disclosing over 2,100 pages of purported mitigation materials, listing 55 penalty phase witnesses and identifying 132 exhibits he may introduce during the penalty phase of trial. So they've even gone all the way to the penalty phase portion. So they're ready to go. But now, after all discovery deadlines have passed and after the court conducted the pretrial conference, a defendant seeks a trial continuance of unspecified length. He bases his request on his claim that his mitigation investigation is incomplete, while state is unable to see whether defendant's ex parte filings to the court contain specifics. His motion does not. His motion does not. Defendant has not shared what new evidentiary materials he seeks to obtain or how additional investigation will actually produce them. Overall, the records before the court shows that the defendant's investigation has already plowed the necessary ground. While defendant is fully entitled to due process, this court should exercise its broad discretion to deny defendant's 11th hour motion. First, defendant cannot show good cause or prejudice. Even under the heightened non-binding ABA standards, he seeks to impose on the court his counsel's resources and investigation to date have been adequate. Even setting aside that, the defense team will still has more time to prepare its mitigation case. Moreover, Idaho Constitution also grants the victims the right to a timely disposition of the case. The court should give these victims right substantial weight in considering the motion. So I guess even like the victims have the right for a speedy disposition of a case instead of just sitting around for years and years and years. Finally, while the publicity surrounding the trial is a challenge, defendant has not shown and cannot show that continuing this trial will make things any easier. It is just as likely that a delay will make it harder to seat a jury. Yeah, I mean, the longer you wait, the more likely somebody is to have read about the case, right? Holy crap, look at that. Cindy made herself available yesterday, and she just got a membership from Alley Cake. It's a miracle, everybody. Alley Cake just gifted a membership. Right, because you just, after I called you out yesterday, you signed back up again, and then the very next day you got a membership. See how easy it is, Cindy? Yeah. All right, so anyways, it is just likely that delay will make it harder to seat a jury. For all these reasons, the court should deny defendant's motion. All right, defendant was, so procedural and factual background. Defendant was appointed his lead counsel in December of 2022. In March 2023, a second attorney was appointed to represent him. Then, in February of this year, a third attorney was appointed to the defense team. The first district public defender has also been participating in the defense. In addition to his lawyers and their staff, defendant has 2 experienced investigators and a mitigation specialist working on his behalf. In January of 2024, defendant moved for a change of venue from Latah County due to publicity surrounding this case and the size of Latah County. His motion was granted, and the case was moved to Ada County. On October 9th, 2024, this court issued the operative scheduling order that contained deadlines for motions, expert disclosures, and pretrial filings. More recently, at the pretrial motion hearing on April 9th, 2025, the court advised defendant counsel to ask for more resources if the defense team needed assistance reviewing discovery. You know, because Ann Taylor's so lazy, she never even looked at it. The state does not know if this has occurred. Throughout the case, defendant has been able to comply with the deadlines in the scheduling order. Pertinent to the instant motion, defendant has, on January 23rd, 2025, made his guilt phase expert disclosures consisting of experts from 16 experts, including a psychologist who conducted a mental health examination of defendant, Dr. Orr, and a forensic psychiatrist who researched his life history, Dr. Ryan. And then on March 3rd, 2025, supplemented his guilt phase expert disclosure with reports from 2 additional experts. As of June 2025, had disclosed in discovery over 2,500 photos and videos, over 3,500 pages of investigative materials, and many megabytes of electronic data related to the guilt phase. On March 31st, 2025, he made his penalty phase expert, disclosure consisting of amended report from Dr. Orr and Dr. Ryan, respectively, plus reports from 4 additional experts, 3 of whom are behavioral health neurology professionals, and as of June 2025, just like right now, has disclosed approximately 2,100 pages of purported mitigation materials and identified 55 defense witnesses and 132 defense exhibits for potential use during the penalty phase in this case. Defendant also opposed the state's motion for examination of defendant pursuant to Idaho Code 18207 and for extension of time to complete rebuttal penalty phase expert disclosures argued May 5th. At that time, defendant did not preview for the state or the court that he would seek a trial continuance, and the court denied the state's request for personality testing by its expert in part because the pending trial date conflicted with the time that would be necessary to explore that issue. All right. So if you guys are out there and you have the ability to help support the channel, I know I'm just reading right now, so it's probably not that interesting or entertaining or whatever you want to call it, but if you have the ability to help support the channel, that would be great. We still try to reach the goals. All right. Let's see. Legal background. Trial judges necessarily require a great deal of latitude in scheduling trials. Accordingly, the decision to grant or deny a motion for continuance rests within the sound discretion of the trial court. When reviewing a trial court's decision for an abuse of discretion, Idaho Appellate Court analyzed whether the trial correctly perceived the issue as one of discretion, acted within the outer boundaries of its discretion, 3, acted consistently with the legal standards applicable to the specific choice available to it, and 4, reached its decision by the exercise of reason. The United States Supreme Court has held that the denial of a motion for continuance is grounds for relief only where the trial court's action is so arbitrary as to violate due process. Similarly, under the Idaho law, unless an appellant shows that his or her substantial right has been prejudiced, the reason of a denial of his or her motion for continuance, appellate courts can only conclude that there was no abuse of discretion. The bare claim that additional investigation could have been conducted is not sufficient to demonstrate unfair prejudice so as to support a motion for a continuance. I would say this, if they came forward and they have a third-party suspect that's just come to light that the judge deems, wow, that's great, that's amazing, I could see him giving more time, but I don't think that's likely going to happen. You know, like let's say they just became aware of a third-party suspect that really seemed to the judge to be legit. You know, and then he maybe gives them more time, but I just don't think that's going to happen. Thanks, Kami. Let's see, where are we at here? Explaining that there are no mechanical tests. The bare claim that additional investigation could have been conducted is not sufficient to demonstrate unfair prejudice as to support a motion for continuance. Let's see. Reviewing Ninth Circuit case law and explaining that there are no mechanical tests for deciding when such a denial violates due process, but that a minimum some showing of actual prejudice must be made. In exercising their discretion, trial courts are also guided by the Victims' Rights Amendment. So the actual victims, meaning the parents of the, and just the victims themselves. All the, I would say Dylan Mortensen, Bethany Funk, the, even the ones that were killed, plus the parents, everybody there, they're all victims. And so it's guided by the Victims' Rights Amendment to the Idaho Constitution. Both provisions entitle victims to a, thanks Kami, to a timely disposition of the case. Section 195306(3) expressively provides that this right shall apply equally to the immediate families, there you go, of families of homicide victims. So that's what they're considered victims. I'm not sure what you're talking about. Defendant couches his motion in terms of his constitutional rights to due process, to effective assistance of counsel. This is the argument. Defendant couches his motion in terms of his constitutional rights to due process, to effective assistance of counsel, to an individualized sentencing determination, and to a fair trial in light of intense media coverage. But he has not demonstrated that these rights, which must be evaluated alongside the victim's rights and the overall administration of justice, will be violated if this case proceeds as currently scheduled. For the reasons disclosed below, the court should deny his motion. The court should exercise its discretion to deny defendant's motion because he has not shown good cause for a continuance or that he will be prejudiced at trial. The court should deny defendant's motion because he cannot show good cause or potential prejudice. Procedurally, he does not explain why he waited to seek a continuance until after discovery closed, expert disclosure deadlines passed, and the pretrial conference happened. Substantially, he ignores Idaho's Supreme Court death penalty precedent holding that counsel is not required to investigate a defendant's entire life before he can be tried or sentenced. State versus Roe. He neither specifies additional areas for investigation nor explains what concrete investigatory steps will bear new fruit or either the guilt for either the guilt phase or the penalty phase. As such, defendant's motion amounts to a request for a perpetual continuance so that his counsel can go down every rabbit hole until the defendant rather than the court deems himself ready for trial. So that's like the late hour third party suspect. Hey, welcome, Tina Humphrey. The law requires no such thing, meaning, so like he's saying, hey, we want to go down every single rabbit hole, and you're just going to have to wait for us to go down every rabbit hole. The law requires no such thing. A reasonable investigation does not mandate a scorch-the-earth strategy requirement that would fail to consider the limited time and resources that defense lawyers have in preparing for a sentence hearing. The court should deny the motion because the defendant's team has had the opportunity to prepare and has adequately addressed the issues he claims need more attention. Defendant's motion is untimely, and thanks for joining Oogla Boogla, Tina. Defendant's motion is untimely given the procedural posture of the case. The scheduling order granted the parties ample time for trial preparation, and it also set several interim deadlines along the way, including for penalty phase, expert disclosures, and mitigation disclosures, which is the primary basis for the defendant's motion. The state also understands that the court set pre-trial conference more than 2 months before trial in order to give the parties sufficient time to prepare for trial after discovery closed and pretrial disclosures and motions practice were completed. If defendant was having trouble meeting deadlines, finding experts, or pursuing red flags, he should have sought a discovery extension or trial continuance long before now. And it says, C. Marquez, stating that court should consider a defendant's diligence and the inconvenience to the court and prosecution when reviewing motion to continue. He did not do so. Instead, defendant retained over a dozen guilt phase experts, 6 penalty phase experts, a mitigation specialist. And so they went past the trial stuff. They were all the way into the mitigation phase of the sentencing, if in case he's found guilty, which he will be. Leading up to the pretrial conference, he exchanged witness lists and exhibits lists with the state without stating that he would be moving for a continuance. While defendant relies on the death is different mantra and argues that extraordinary measures must be taken to protect his rights, he cites no authority for the proposition that reasonable scheduling orders should not be enforced in death penalty cases. Indeed, defendant recently argued that the state properly delayed in seeking an extension of time for its rebuttal phase expert disclosure. Objection to state's motion for examination of defendants pursuant to Idaho Code, blah, blah. I hate reading the codes. It's just like, let's see. Indeed, defendant recently argued that the state improperly delayed in seeking an extension of time for its rebuttal phase. And for the, let's see down here. The state has not provided the necessary proof. This is in this, I guess I have to read it, this part up here. Objection to state's motion for examination of the defendant pursuant to Idaho Code 18-207 and for an extension of time to complete rebuttal penalty phase expert disclosure filed April 29, 2025. The state has not provided the necessary proof of good cause to warrant an extension of such a significant deadline so close to the trial date. So they were denied, I guess, right? Or they filed a motion. The same principle should apply to him. Defendant's motion is untimely and weighs in favor of its rejection. And B, defendant purported need to conduct additional investigation is unsupported and does not establish prejudice warranting a continuance. Defendant bases his motion on a claim of insufficient resources and the need to conduct more investigation prior to trial. But he has not demonstrated that he is being deprived of anything that he seeks. Hey, thanks, Leanne Bell. Thus, defendant claims that the current state of the defense team preparations are matters of speculation and not the type of demonstrable reality needed to support a continuance based on defendant's constitutional rights. Defendant's legal resources have been more than adequate, says right here. That's another. Hey, thanks again, Tina Humphrey. Let's see. Defendant has 3 trial attorneys, including a lead attorney who has represented him from day one, Ann Taylor, 2 investigators, and the assistance of at least 1 additional public defense attorney. He also has engaged an outside mitigation specialist to assist in obtaining materials for use during the penalty phase. This record reflects that this defense team has been working hard for defendant and, as explained below, has met the professional standards for the defense of a death penalty case. Yet, defendant still claims that the court is cutting off his review of discovery. This is unfounded. Defendant's attorneys have had sufficient time to review discovery and have not established any discovery violations by the state. They have been able to identify over 1,000 exhibits and nearly 200 witnesses for trial. Indeed, the court also recently admonished defendant's counsel to seek additional resources from the resource judge if they needed more assistance to review discovery and prepare for trial. Defendant has not claimed that he sought more resources and was denied. neither the size of his legal team nor the need to continue to review discovery form a valid basis for a continuance. This is pretty good, pretty well written. Defendant's expert witness resources have been more than adequate. I guess, what does it say up there? Defendant's legal resources, now it's Defendant's expert witness resources have been more than adequate. Defendant has been able to retain a large retinue of experts, never heard of that word, including 6 experts focused on mitigation for the penalty phase. 5 of these experts are mental health professionals. Both a psychologist and a forensic psychiatrist have examined defendant on multiple occasions, reviewed in social and medical history, or his social and medical history, and diagnosed him with autism, OCD, and ADHD. Collectively, these experts took a deep dive into the defendant's entire life, including by interviewing his family, teachers, co-workers, and even psychologists who evaluated defendant as a child. The extensive, so that's interesting. Now we know that there's information that's going to be presented that he was looked at as a child for his mind. That's pretty interesting. The extensive investigations by these experts contradict defendant his claim that he needs more time to complete a social history investigation. In the cases he cites, counsel was ineffective for failing to explore mental health conditions or for failing to provide mental health experts with sufficient background information. In contrast, here, defendant's mental health expert have had access to a significant amount of people and materials and have created fulsome histories through their own investigation. Defendant's claim that his team needs to follow up on red flags is also unsubstantiated. In their reports, neither his psychologist nor his forensic psychiatrist indicated they could not render opinions because of unexplored areas. In fact, the forensic psychiatrist concluded that defendant showed no signs of other serious psychotic disorders. That's interesting. So all he has is the ADD, the autism, I guess, and ADHD, but no like psychopath or psychopathy. Tellingly, defendant did not seek an extension of the penalty phase expert disclosure deadline. Defendant's claim that more expert testimony is needed is speculative and does not identify what new information would be uncovered by further investigation. This is fatal to defendant's motion, affirming denial of a continuance where it would not have served a useful purpose because counsel sought information based on mere speculation. Right. We're not going to have a continuance because the prosecution goes, yeah, I bet you there might be something out around here, so give us time. We're going to go look into that too. Defendant's counsel investigation into his life story has been more than adequate, and his reliance on ABA guidelines is misplaced. There is no authority to support defendant's desire for more time to conduct a scorch-the-earth life history investigation. Court recognized that all cases, including death penalty cases, are constrained by limited time and resources. Let's see. We have never held that counsel has a duty to uncover every aspect of a defendant's past. This is a quote from one of the citing up here. It says, "We have never held that counsel has a duty to uncover every aspect of a defendant's past and to present all evidence that might bolster a defendant's mitigation case. Rather, trial counsel's resources are limited, and the strategic decision to emphasize certain aspects of a defendant's background at the expense of investigating others is both reasonable and wholly acceptable. But hey guys, if you're out there, if you can help support the channel, that'd be great. Whenever you're reading these long documents and the support is minimal, it sort of feels like you're just kind of like nobody's really interested in what you're reading. And maybe that's the case, but I'm just reading the entire document because I think this could be a very important document in terms of decisions that are going to be made soon. And we don't know when the trial's supposed to happen August 11th. And this document right here is trying to keep the defense from extending it out into oblivion. Faced with authority, defendant turns to straw man arguments and non-binding guidance to conjure up alleged prejudice. First, he cites cases where death penalty sentences were overturned because lower courts failed to consider mitigation evidence. But there's no danger of that here. And so I remember this is in response to that long document that they put out. And that was the one that I think ChatGPT actually was kind of like, wow, I thought it was good arguments. But then, I think it was just a couple days ago, wasn't it? First, he cites cases where death penalty sentences were overturned because lower courts failed to consider mitigation evidence. But there's no danger of that here. Starting the trial, instead of allowing defendant to pursue a mitigation investigation with no end in sight, does not amount to denying him the right to present a constitutionally adequate mitigation case. In any event, the current issue before the court is a request for a continuance, not the admissibility of mitigation evidence or the performance of counsel. The court's decision remains a matter of discretion. These are more citings here. No. Affirming trial court in a petition for habeas corpus because the defendant failed to demonstrate that the state's court rejection of a continuance was objectively unreasonable. Finding that the trial court's denial of a last-minute continuance did not violate defendant's rights. The court will be well within its discretion to bring this case to trial after 2 years and already robust defense investigation. And then C. Dixon versus Ryan, affirming the decision to deny a motion for a continuance where the trial court cited the overall length of the case, the interest of the victims, and the mitigation investigation done by prior counsel. Second, defendant relies on the ABA guidelines for the appointment and performance of defense counsel in death penalty proceedings to list all the things that the counsel needs to accomplish. The exercise is meritless as a matter of law and of fact. As to the law, the Idaho Supreme Court has declined the invitation to adopt these guidelines. Let's see, repudiating the guidelines in the context of post-conviction discovery and rejecting a claim that the heightened procedural safeguards should be employed in discovery in capital cases. Let's see, for its part, the United States Supreme Court has ruled that ABA guidelines are just that, only guidelines. Beyond the general requirement of reasonable, specific guidelines are not appropriate. As a factual matter, even if the court looks to the ABA guidelines, the records reveal that defendant's counsel has complied with them. Table 1 and Table 2 attached to the brief cross-reference the list of tasks defendants set forth from the ABA guideline with the actual records of this case. Yeah, so we currently have 0 coffees and 1 channel member, and a big struggle tonight. As a factual matter, even if the court looks at the ABA, I guess we're down here now. The results show that an appellate court will be exceedingly hard-pressed to rely on the ABA guidelines or any other basis to find that defendant has suffered prejudice if trial proceeds as scheduled. It also shows that extending defendant's mitigation investigation will not serve a useful purpose, because at this point, any new information counsel hopes to find is based on mere speculation. Number 4, defendant's ex parte filing should not cause the court to grant his motion. Defendant filed ex parte, an additional document that purports to outline what new evidence he might seek and what strategies or tactics he might use to obtain such evidence. Initially, the court expressed skepticism that defendant's motion was properly filed ex parte and ordered defendant to provide a redacted copy of this filing to the state for its address in the response. Defendant then objected that order, and the state now understands that the court has decided not to require disclosure of the ex parte filing. While the state does not concede that defendant is has valid grounds for his objection, it will not address the objection given the court's decision. The state, however, does request that if the court has identified a basis in the ex parte filing to grant defendant's motion, that the court allow the state to respond to that particular issue. Regardless of the ex parte filing, the court should deny defendant's motion because of the resources he has at his disposal and the significant work already done to support his mitigation case. The Idaho Constitution Victims' Rights Amendment is another basis to deny defendant's motion. So this is the victims' rights. So while defendant's reasons... Hey, thanks, K-Me, trying for a reading wave. While defendant's reasons for a continuance are unpersuasive, there is another reason to deny his motion. The victims in this case, including the immediate family members of the homicide victims, have a right under the Idaho Constitution to the timely disposition of this case. Given that it has been nearly 2.5 years since the defendant's arrest, the victims' rights and their desire for justice weigh in favor of proceeding to trial as scheduled. While the term timely disposition is not defined, it must mean that at some point a trial court can decide that the administration of justice outweighs the defendant's desire to continue preparing his case. This is one of the purposes of the Idaho Victims' Right Amendment and is consistent with Idaho cases requiring a defendant to show actual prejudice in order to successfully challenge a decision to deny a motion to continue. Yeah.
Ocean wave emoji.
That makes
Ocean wave
sense.
emoji. Ocean wave emoji.
Yeah, so you could sit there forever and go, yeah, we just need more time, we need more time, we need more time. And at some point the judge has to say, hey, you know, the victims have rights too. And let's see, what was that last part? That is one of the purposes of the Idaho Victims' Right Amendment and is consistent with Idaho case requiring a defendant to show actual prejudice. Yeah, so how is the defense team showing that if they don't do a continuance, then they're being affected? There's no proof of anything. You know, they think that, well, they need time. This is what the defense really believes here. They want to have the results of the investigation into the leak. and then they want, and then have that in their hand, and then seek a remedy. That's what they really want. They want the result of the investigation, and then they can seek a remedy, and maybe that'll involve delaying the trial, etc., etc., etc. Thanks, Tina Humphrey. Huh? Who are you talking to, Sandy? What do you mean texting? What do you guys what are you referring to? I don't understand. Do you expect certain people here at a certain time? And I don't get it. I'm just trying to read the chat. Like, where's somebody saying anything about them? Been nearly 2.5 years since the defendant's arrest. The victim's rights and their desire for justice weigh in favor proceeding to trial as scheduled. While the term timely disposition is not defined, it must mean that at some point a trial court can decide that the administration of justice outweighs the defendant's desire to continue preparing for the case. That is one of the purposes of the Idaho Victims' Rights Amendment, and is consistent with the Idaho case requiring a defendant to show actual prejudice. There you go. Okay. What do you guys, are you guys talking about the Karen Reed case on there? Jesus. Let's see. In his motion, the defendant cites many cases where counsel failed to adequately prepare for trial sentencing, but he cites no case where a court found that over 2 years was an adequate amount of time to prepare, nor could be. He concedes that the Sixth Amendment only means that a defendant is entitled to a reasonable period of time before trial during which counsel might prepare the defense. I just don't know who was asking, Sandy. Nobody up there was asking about like where they are or anything like that. I just don't understand why it was put in there. He conceded that the Sixth Amendment only means that a defendant is entitled to a reasonable period of time before trial during which counsel might prepare the defense. While he appears to want unlimited time, the defendant has already had reasonable amount of time to prepare, as demonstrated by the substantial quantity of evidence his attorneys have amassed. Against this backdrop, the court can properly rely on the victim's constitutional rights as a basis to deny his motion. You know, it's crazy. This just shows that that this is like really, you know, the prosecution is ready to go. I mean, they're just like, come on. They're not wanting a delay of any kind. Despite intense publicity, the court should exercise its discretion to deny defendant's motion and proceed to trial using its carefully planned jury selection process. Thanks, Michelle H.
Let's go freeze. Ocean wave emoji.
Be a tough one.
Ocean wave emoji. Ocean wave emoji. Surfer emoji. Surfer emoji.
There's no doubt that the publicity surrounding this case, including but not limited to a recent Dateline TV show containing non-public evidence, poses challenges for the court and both parties. The state reaffirms its commitment to comply with the court's non-dissemination order, to do everything in its power to prevent leaks, and to assist in determining which person or persons provided non-public information to Dateline. However, defendant's reliance on the Dateline episode to support his motion is misplaced, and for several reasons. The first reason is the question of whether defendant can receive a fair trial is not answered by the amount of any of the nature of pretrial publicity. Rather, it depends on whether a fair and impartial jury can be seated, as the United States Supreme Court has said. It says to hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient.
Ocean wave emoji.
Let me just see what this is saying again right here. Thank you, Ali K. First, the question of whether a defendant can receive a fair trial is not answered by the amount of and the nature of pretrial publicity. Rather, it depends on whether a fair and impartial jury can be seated, as the United States Supreme Court has said. Let's see. To hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court. Yeah, so the thing is it's never been a law that a juror cannot have heard about a case. It's whether or not they can maintain impartiality when being on the jury. Can they, just base their decision on the facts of the case and use none of the information that they had heard about? And many, there's cases like O.J. Simpson. Do you think there's one person on that jury that never heard of O.J. Simpson? There's no way in hell. Everybody had heard of O.J. Simpson. Accordingly, the Idaho Supreme Court has long recognized that trial courts can successfully select an impartial jury despite widespread publicity. There you go. Let's see, and it says, a death penalty case, the Idaho Supreme Court disagreed with the defendant's claim that extensive publicity prior to trial deprived him of the opportunity to be tried before an impartial jury, because each juror was extensively questioned to determine the degree of their exposure to the pretrial publicity. When the defendant later sought federal habeas corpus relief, the Ninth Circuit examined the voir dire process and found no prejudice, even though on the day of jury selection, the case was covered on the front page of the local newspaper, as well as on TV and the radio. Here, the court carefully crafted jury selection process has every chance to produce an impartial jury. Because of the sensitive nature of the court's voir dire procedures, the state will not address the mechanics of jury selection in the public filing. But suffice it to say, if an individual has been so impacted by the Dateline episode or any other publicity that they cannot be impartial, they will not be seated as a juror. Indeed, the case is not the Ada County judiciary's first experience with a highly publicized trial in recent years. Like the court in the Vallow Daybell trial, this court is well equipped to select a jury, to handle ongoing media coverage, and to conduct a fair trial in the Ada County Courthouse. Second, the Idaho Supreme Court has rejected the defendant's theory that a continuance is necessary to allow media coverage to dissipate. Theory that, so they want a continuance and the media coverage will dissipate. But no, it's just going to keep getting covered and covered and covered. Federally argues that this is one of the, see Federally 710 page 2D at 1206. Federally argues that the trial judge should have granted continuance to allow the harmful press coverage to dissipate. However, as stated above, there is every indication that an impartial jury was impaneled and that federally received a fair trial. As the court correctly noted at the pretrial conference, delaying the trial will only allow more opportunities for pretrial publicity. There's no reason to think that media coverage in this case will dissipate. So proceeding to trial as scheduled may actually avoid any negative consequences from future publicity. Defendant, dissipation cases occurred in the 1960s and involved communities where it was presumed or demonstrated that residents had already formed opinions about the case based on local media reports. Right. Yeah, I wouldn't make a good juror on this case. I mean, I could sit there and look at the facts and everything like that, but they wouldn't ever accept me because I've already said that I believe 100% that Brian Kohberger is the killer. Now, if I was on, when we're watching the trial, if all of a sudden there's this mountain of evidence that comes out that absolutely points away from Brian Kohberger, I'll be stunned, but I'll have to go that direction, okay? I mean, that's just what it is. People, you don't have to, you can believe something, and then every once in a while, this isn't going to be one of those cases, by the way, but it's just sometimes there's evidence that you go, oh my God, that's crazy. Look at that. That does exonerate somebody. But there isn't any in this case. I mean, if there isn't one shred of information of any kind that exonerates Brian Kohberger. Nothing. Let's see. There isn't even any exculpatory information. Something that you go, wow, that sort of clears him. That's weird. I mean, there's zero. But hey, guys, any chance we could get the support up for the channel? We are nearing a third of the way through the month. Trying to get the month going on so that at the end of the month we can still do all the good stuff that we do. We're currently at a stage where we keep sort of plummeting in terms of what the average will be for the end of the month. So I need you guys' support if you have the ability to. But if you don't have the ability to, then that's it. You don't need to help support the channel, or you don't need to anyways. It's just if you want to, that would be great. You guys know, I express on this channel every single day what we are doing here. We're actually 2,000 away from giving out $250,000 in 5 years. All right. Now you hear a lot of complaining and bitching and moaning from a lot of the people that follow the channels that don't give a nickel to a soul and make thousands and thousands of dollars on their videos and live streams, etc., etc., etc. I'm just asking if you guys are out there, if you could please consider supporting the channel. We're having, yesterday wasn't the greatest. I did 3 hours of streaming at the end. Prior to that, it was okay, and then today it's, about a fifth of that. So. Let's see, where are we at here? Here, venue has already moved, and it had moved it. God, I don't even know what the hell they're saying here. Let's see. Defendants' dissipation cases occurred in the 1960s and involved communities where it was presumed or demonstrated that residents had already formed opinions about the case based on local media reports. See Beck versus Washington, citing Irvin, where sensational publicity adverse to the accused permeated the small town in which he was tried. The voir dire examination indicated that 90% of 370 prospective jurors and 2/3 of those seated on the jury had an opinion as to guilt. Here, venue has already been moved, and if the court, I think it's if the court, it says it, if the court will use let's see, already moved, and the court will use a much larger pool of potential jurors than in defendant cited cases. This case is also proceeding in a highly fractured media landscape and bears little resemblance to what prevailed in the 1960s. What happened in defendant cited cases has no bearing on whether the court can select a sufficient number of impartial jurors in this case. The court should deny defendant's motion because he has not shown that the publicity surrounding this case will prevent the fair trial. Did anybody hear what I just said a minute ago? It's just wild, man. Conclusion. For the foregoing reasons, the court should deny the defendant's motion to continue, dated this 5th day of June. And, you know, a bunch of certifications, a table down here, media history, contain, you know, we don't have to go through all this stuff, but there you go. We just went through the entire document. Yep. No, I don't think so, Alley Cake. Yeah, whenever there's a time where I go, hey, everybody, and I explain, and then it's just nothing, then that means the odds of getting a goal that night are 1 in a million. So, nah, it's not happening. Let's see. Oh yeah, he's doing a presser. Is he trying to do some dissing? Who knows? So how's the protests in California going? Thanks, Alley Cake. We just made it to a 5th of the goal, and that's the goal that I don't even donate 5 memberships from. The inmates are. What do you mean, the inmates? I don't get it. Thanks, Susie Clue, for the coffee. Right. Thanks, Tina Humphrey. And they are just causing trouble. No, but it's all the National Guard's fault, you guys. It's all the ICE agent's fault. That's whose fault it is, you know? And you know what it really is people, they wait for something that they can claim is a reason, because they're all just waiting to be able to have another riot and loot stores. Late last night, after we ended the show, they started looting stores in Los Angeles, because that's really what it's all about, you know? That's not fair, Gray. Those are just a few bad acts. Oh, really? Did you see the number of people running through there? Yeah. Must be part of something. Thanks, Tina Humphrey. Yeah, I don't have. Yeah, it's going to go. Like I said, the first day that I started covering, I go, this is going to spread around the country just like it always does. Pretty soon it'll be in Portland, and you know, just the way it is, man. It's the way it is. Yep, they all need to be part of something. Let's see if there's anything going on. So what's Gavin saying?
He's ordering our American heroes, the United States military, and forcing them to put on a vulgar display to celebrate his birthday, just as
forcing them? What in the hell are you talking
dictators have done in the past.
Everybody's like putting clown faces. He's such an embarrassment.
This isn't just about protests here in Los Angeles. When Donald Trump sought blanket authority to commandeer the National Guard, he made that order.
He's got echo now. Somebody's messing him up.
He made that order apply to every state. This is about all of us. This is about all of us. This is about California may be first. California may be first, but it clearly will not end here.
The invasion was 99.9% stopped.
Well, that was so. This is all day here.
Shift.
Hold on.
Of things. One, the
area.
Let me go to the beginning. You guys, I need your guys' support tonight to try to reach the goals. Thanks.
Went to see their mothers and their fathers came to talk to them.
Is pulling a military dragnet all across Los Angeles, well beyond his stated intent to just go after violent and serious criminals. His agents are arresting dishwashers, gardeners, day laborers, and seamstresses.
Yeah, illegal aliens.
That's just weakness masquerading as strength. Donald Trump's government isn't protecting our communities. They're traumatizing our communities. And that seems to be the entire point. California will keep fighting. We'll keep fighting on behalf of our people, all of our people, including in the courts. Just yesterday, we filed a legal challenge to Donald Trump's reckless deployment of American troops to a major American city.
God, you're so...
Today, we sought an emergency court order to stop the use of the American military to engage in law enforcement activities across Los Angeles. If some of us could be snatched off the streets without a warrant, based only on suspicion or skin color, then none of us are safe.
No, that's bullcrap.
Authoritarian regimes begin by targeting people who are least able to defend themselves, but they do not stop there. Trump and his loyalists, they thrive on division because it allows them to take more power
our
and
dear
exert
leader,
even more
our dear
control.
leader, they say.
And by the way, Trump, he's not opposed to lawlessness and violence as long as it serves him. What more evidence do we need than January 6th? Ask everyone. Take time, reflect on this perilous moment. A president who wants to be bound by no law or constitution, perpetuating a unified assault on American traditions. This is a president who...
You know what? See, what he's saying right now is actually what inflames the riots. See, this is what they do. They tell you how this guy in there, he's this dictator. He's going to do this, he's going to do that, he's going to do this. So why wouldn't these people do what they're doing? See, that's what he's doing right now. He is inciting the mob right now.
Amendment.
See?
And the threat
oh my God.
Them.
Just like, remember before when they would say he's worse than Hitler? Like, Trump is Hitler? Well, then, doesn't that give them the right to do anything? You know, pretend that Joe Biden is Einstein, you know, like all these things that they do over and over and over and over again, claiming this and claiming that. It gives them the right, and it makes them feel like it's okay to do whatever it is, because after all, see, what he's saying right here is what leads to attempts on the lives of presidents. Stuff that he's saying right now. Because people go, wow, you're right, wow, he's ruining our country. Oh God, wow, because people are that stupid that they believe that kind of stuff.
At threat, he's dictating what universities themselves can teach.
Look at
this.
He's targeting
law firms and the judicial branch that are the foundations of an orderly and civil society. He's calling for a sitting governor to be arrested for no other reason than to, in his own words, for getting elected. And we all know this Saturday, he's ordering our American heroes, the United States military, and forcing them to put on a vulgar display to celebrate his birthday, just as other failed dictators have done in the past.
A vulgar display.
Look, this isn't just about protests here in Los Angeles. When Donald Trump sought commandeer the National Guard, he made that order apply to every state.
See, I rewound it. Now we're back to the doubling up echoing.
In this every state, and this is about all of us. This is about all of us. California may be first. California may be first, but it clearly will not end here.
Right. You're creating
democracy. Democracy is under assault.
The first time she is in downtown LA at that prayer vigil
of the city, but again,
on culture, on history, on science, on knowledge itself, databases quite literally are vanishing.
Listen to these guys. The entire country is, we're just being it's insane. Absolutely insanity. I can't believe it. Well, I can believe it. And what's even scarier is people believe what he's saying right there. And they already believed it before he said it. But now that he says it, they are totally justified now in doing riots and violent protests, whatever the hell you want to call them. They're totally justified now because, after all, there's a dictator in there, man. This is Hitler, right? That's what they believe. And it's scary. They always do this right here. They did it all the entire time when he was running. That's what led to 2 different attempts on him. They did it in his last term. It's crazy. It's unbelievable. Let's see what's going on over here. It's in Chicago, has a bunch of people. I'm sure Portland will have something. Yeah, tell me other than January 6th, when was the last time that, even before that or after, that you see large numbers of Republicans only trashing a city? And the answer is never. You just never see it. Okay? And that's just the reality. I don't know what's so weird. I mean, no, you got it wrong. That's the wrong one, little D. They've never trashed anything. Yeah. Hey, good night, KME. I'm just looking at some live streams over here. Is anything interesting?
Learn how to create AI agents that work for you while you sleep.
This week, we are starting an
Chicago. Yeah, I think there's going to be a lot of looting and burning and stuff tonight. Nothing in Portland reported yet. Yeah, well, Portland's, they just they'll just wait for their time and be running around. But what do you guys want to talk about? I wasn't sure if I don't know if I can, play these live streams out there like I was doing. Had to get rid of them. Well, I didn't have to. I just I mean, I know I'm talking through it and whatnot, but I don't know. It seems like, right, you know, when you're live streaming national events like that, they shouldn't be able to be, they should just be public. It's not like your own production of something. You're just filming. I don't know. I think I'm just going to take off, you guys. This is just one of those nights, I guess. So thank you to Alley Cake, Forgetful Mandy, Natalie, Simply Suspicious, Shauna, Alley Cake, K-Me, and then we had K-Me gifted a membership. Then we had Tina Humphrey, Leanne Bell, Ann Humphrey, K-Me, Tina Humphrey, Michelle H, Alley Cake, and K-Me again, and then one Coffee, Susie Clue. All right, everybody, thanks for being here. See you guys later.
Yeah, I've been doing this true crime thing for quite a while now. And during this whole time, I have not seen one person that is a crime dissector, plug rejector. I'm a certified human lie detector. Gonna get ya on a stretcher if you try and play me like an old projector. Crime sector is my nectar. Professor Grader's gonna give another lecture. Crime collector, freak connector, and I'm always gonna be a pup protector. Fool deflector, interceptor, and I'm meaner than a specter with a vector on his pector. With all respect, y'all, just remember I've a temper fucking checked ya. I have no agenda, I'm no pretender, and I'll serve it to you straight without the blender. And in the end, I'm gonna send ya on a mission to reveal the true offender.
Yeah, so I'm actually going. I'm going fishing in the morning. Well, what time is it? 6:53. Well, let's see. I have to go get up at 5 in the morning. So let's see. What time would I have to go to bed? I don't know. I don't really have. I mean, if you guys have stuff you want to talk about and everything, that'd be great. But we were struggling so badly, and I just, you know, I'd rather just kind of hang out and go to sleep. Yeah, hopefully I'll catch a big fish. Used to be a good place. When I was a kid, I'd go there, sneak in. I remember this guy taught me how to do the, what's it called, the Texas rig. And I know you say that a lot, Sandy. We do the Texas rig, and we what it is, you put there's like a sliding weight on a line that goes to a hook, and then that goes into a rubber worm, and then you cast it out, and then it sinks slowly down. But this guy taught me when I was at Oregon State. I went fishing. He taught me how to do it, and it was so interesting because you cast out, and you just right when the worm hits the water, you lock your bail basically, and then you watch the line sink, and you don't you actually don't, like, you're not waiting to feel something. You just watch your line. So when the line's sinking, you know how there's this little slack, it's got that little bend in it? A lot of times it'll get slack really fast, and that means a fish swam towards you. And then sometimes it would actually start moving. The line will start moving to the side all by itself when you're not feeling anything on it. And when it's doing that, you just reel in a little bit, and then just boom, you just pull back and bam, right into the fish's mouth. It's pretty crazy. And so, you know, I'm going to try the newer wacky worm setup that they use. Yeah, that's right. I don't know if it'll work. I don't know. Yeah, I'm on the West Coast. Right. It's only 7 here. I mean, I don't know. If you guys have something you want to talk about, I could stay on. But the problem is you didn't have anything when I asked. I did a whole thing. I went over the entire document, read an 18-page document from a case, went over the update in Thomas Crooks, And then nobody had anything that they wanted. They wanted to go over the the people not rioting, whatever you call it right now, protesting. But I don't know. Whenever I go to the protesting, I lose subs over and over and over again. I lost 50 subs going over the even though I gained subs on the one video that I put out, I lost over 50 subs covering the protests. Who the hell wants to do that on a daily basis? I can't say what I think or anything, or you just get completely creamed by the people watching. How cool is that, huh? Yeah. Jim? Huh? I don't know what that means. Jim. Peaceful protests with beautiful Waymo fires, and yeah, I mean, all they were doing was roasting marshmallows. I don't know what the problem was. I was watching on TV. I don't know. I guess I'm still sitting here. Useful looting. I don't know. I try to fish for bass, bluegill, crappie, all the different types like that. And the mayor have this under control. Oh yeah. I'm gonna go fishing tomorrow. Yeah, I don't really have. Okay. All right. Well, anyways, thanks everybody for being here. Sorry the show was kind of short. We were just really struggling, and I can go rest and go do something else. So thank you very much. Hope you got something out of what we did cover. Talk to you later, and be safe.